So, how many of y'all have heard of a small estate affidavit?
This morning.
So, most states have what's called the Small Estate Act. And what it says is if a person passes away with a probate estate under a certain amount, and it varies per state what that amount is, they can avoid probate. Okay? So in Virginia, that amount is $50,000 in personal property, not real estate, personal property. So if a person passes away with $50,000 or less in personal property, you can't, let's say it's just in a bank account, nobody else's name was on it, it was a beneficiary name, you can't get to it, all right? It's one of those cases where I'm gonna have to go qualify as executor, as administrator to get to this, the small account under $50,000. What you do is you can wait 60 days. This requires a 60-day waiting period from the date of death. And then an attorney can prepare it. It's a one-page. It's called a small estate affidavit. And what it says is this person passed away on this date. 60 days have lapsed since then. I am an heir of the estate. Either they died with the will and I'm a beneficiary, or they died without a will and I'm an heir at law. And you take a death certificate and the small estate affidavit signed and notarized to the financial institution where that asset is, and they give it outright to you. And you have no obligation under the law to pay off creditors with it or anything else. You just give the money outright. So a lot of times when people want to go, someone's passed away, I say, well, how much was in their estate that we can't get to? Total in their estate. And if it's under 50, I'll say, let's just do a small estate affidavit. If you can wait 60 days to get the money, and then we'll go to the bank and get the money out. So a lot of people don't know about this. If there is a will, you still have to probate it. You can mail a will to the courthouse and say, put this on record. You don't have to go qualify as executor or anything like that. Y'all have any questions about that?
You answered some I didn't know I had.
Well, I had a couple from Ohio from Ohio the other day who had driven in because his mother passed away 2 Easters ago. And there was like a $2,000 bank account and a credit union they couldn't get. And the will was a copy of a will, which is no good. You gotta have the original will. And they came to my office and they're like, how can we get this original will probate? And how can we get this copy probated and all this? And they gave me 3 options. And I was just, both 2 of the 3 involved getting the courts involved and all this time and expense. And I was just like, let's just prepare a small affidavit and give you the money out. And I called the bank and I explained to the bank, to the personnel, what we were doing. I was like, there are some things I do for clients I'm not really, there's a gray area and we don't know if it's going to work. But this is black and white. We have 2,000, that's all they had. And they're bringing the affidavit to you. And they got the check out the next morning at the bank, the credit union. So what could have been like a long drawn out process if they didn't know about this just was very easy. So that's good. So with trust, 3 of the documents we're looking at today, everybody should have a will, power of attorney, a medical directive. Trusts are not for everybody. Trusts are not just for people who have a high net worth. When I was growing up, I was on this farm and we just had pigs in the backyard. It was like, oh, those trusts are fancy things. I don't need, we just had no use for a trust. That's not the case. There's no minimum amount that you have to have to open a trust account and have a trust. It all depends on what your situation is and whether it would be beneficial to you. You might have $20,000 to your name and a trust might be worthwhile. I've done a trust for someone, they have $18,000 that was needed. So it just depends on your situation. Whenever you do have a trust, it's twofold. You have a trust agreement, which is just a legal document. It can be 10 pages or so, and it spells out the terms of the trust. The grantor is the person who establishes the trust. If I have money I want to put in a trust and I sign the trust agreement, I'm setting it up. Trustee is the only person who has access to the trust, who has any access to the money and control of the trust. And the beneficiary is the person who is to benefit from the trust. There are 2 types of trusts, big picture. There are trusts that are created while you're alive. So if I said, okay, I've got money from my grandmother and I want to go put it in a trust, that's called an inter vivos trust. It's during my lifetime, I'm setting it up. And I can make it revocable, like a living trust, or I can make it irrevocable, where I can either change it during my lifetime, do away with it, or not. The second kind is called a testamentary trust. That trust does not come into effect until the person passes away. So if I had a will that said, I have a 3-year-old child, and I want to leave money in that to that child when I pass away, but I want to go into trust for them. If something happened to me and that trust came into existence, that's called a testamentary trust. And they're always irrevocable because I'm no longer around to revoke it. A pour-over will is a term that we use for if I have a trust already created and I want everything in my will to go into that trust, then it's called a pour because everything in your estate pours into the will. That's just terminology. And you may have heard of revocable living trust or revocable. I don't know the proper way to say it. I don't say a lot of things the right way, so that's not new. These are useful in a lot of cases. I don't tend to do a lot of them because I do a lot of long-term care planning. And revocable trusts are not exempt assets. So if I need to get on Medicaid or I need to get somebody on Medicaid and they have too much money, if I want to go put it in a revocable trust, Medicaid doesn't care. They're still going to count that money against them as an available asset because it's revocable. But they are useful for people because you can avoid having, if you have everything you own in the trust, you can avoid probate because when you pass away, if you're trustee, then you can name a successor trustee. And they just step up to the plate and deal with the trust funds, either give it outright to people or continue it, continue the trust. It helps people if I had to go to a hospital or if I became incapacitated, you wouldn't have to worry about powers of attorney and all of that because whoever's named as successor trustee, if I'm the initial trustee, would step up and have full access to everything in the trust. And it's also, if I had everything I owned in a trust when I passed away, then I don't know about probate. And whatever I own and however I leave it, is all written in the trust, and it's very private. So if I wanted to favor one child over the other, whatever I could. That's a lot of the benefit of doing your trust during your lifetime, because that's not public record. A will is going to be public record, but a trust is not. And then if it's revocable and you're the trustee, you still use the money just like it's in your name, except it's in the trust name. Disadvantages, it's not exempt as a resource for VA, for Medicaid, for SSI, and it's not protected from any creditors you have. Irrevocable trusts are the kind of trusts I normally do. Again, if you have all your assets or some of your assets in the trust, it can help avoid probate. It's a smooth transition. If the currently serving trustee is no longer able to do it, the other trustee just steps into that role, and it's very easy on the family. Irrevocable trusts can help shelter assets if you're trying to get on Medicaid, but there's a 5-year look-back period, which y'all may have heard of. So you can't say, I really want Medicaid, but I have too much money, I'm going to go put it in trust, this irrevocable trust. There's a 5-year look-back period. So if I have a client who's 50 years old, or whatever, if they say I want to put the money in a trust, I'll say, okay, well, if you need Medicaid in the next 5 years, there's no way you're getting on it because you're moving these funds, but after the 5 years, that whatever's in the trust is exempt. Medicaid cannot look at it. So special needs trust, supplemental needs trust, have y'all heard of those? These oftentimes are done for children who have like birth defects or who have some sort of, people who have an accident and become disabled and are on public benefits but can't have a lot of money in their name. I also do them for older people who are on public benefits. I have a gentleman, he is in his 60s, and he was in a car accident. But he was already on Medicaid, already on SSI. So when he got the personal injury settlement, it was going to jeopardize his benefit eligibility. So I moved it into a special needs trust. There are lots of rules for those, but those are really useful because they're supported. They're not to They're to help increase the quality of life for that individual, because if you're on public benefits, you can't have a lot of money, but these trusts let the family have extra funds to support you and pay for things. Irrevocable trusts, not all irrevocable trusts, but special needs trusts are not exempt for VA benefits, which is odd, but if you have, for Medicaid, if I have someone who I want to get on Medicaid, and they have a disabled grandchild, I can move as much money into a trust for that grandchild as I want, and then get them on Medicaid. But VA does not look at it that way. They still look at that money as available to the person that wants to get on the benefits. And it also may not be protected from creditors unless it's set up a certain way, which usually it's not. So usually the funds are available to the grantor's creditors.
Is it listed as an asset?
For,
The disadvantages, the very last one.
yeah,
The credit is counted attached. Is it listed as an asset?
yes, if you're a beneficiary of it. And if you're named, a lot of times you're named as a trustee. There are certain rules for IRS that if you have a completely neutral third party named as trustee, it may be able to protect it from future creditors, not current creditors. So the second, this is the third document, is the power of attorney. Y'all heard of this term before? Power of attorney in Virginia only deals with financial matters. It's not dealing with health care. We will get to that document. A lot of times in different states, they have a financial power of attorney and they have a health care power of attorney. Virginia did away with that, and they said, okay, power of attorney is for financial, advanced medical directive is for health care. So that's the next topic we'll talk about. Terminology, when you have power of attorney, the principal is the person making the document, authorizing another person to help them with their financial affairs. And the agent or the attorney of fact is the person named to help. So if I say my daughter can help with my financial affairs, she's now my agent. Yes.
Back to wills for just a
Sure.
second. If you pass away, and you have some bills in your own name, not cold
Right.
what happens to those? Are those have to be paid off by the estate or what?
If someone qualifies on the estate, those bills have to be paid first before any money can be distributed to the heirs. If there's no probate estate, if all you had were joint accounts or accounts with payable on death with beneficiaries' name, and all that money goes outright, outside of probate, then there's no money in the estate, in the probate estate, to pay those debts. But if someone qualifies on the estate, those debts have to be paid. So that's why I recommend doing payable on death designation forms for your bank accounts and that sort of thing. Because then whoever you want to get the money can go get it without having to worry about bills. Okay, so power of attorney. Power of attorney is a very powerful document. It's not something you say, I think I'm gonna, give it to my daughter because I mostly trust her. I think she'll do right now. You got to give it to someone who you trust wholeheartedly. I've had seen people, most people do not abuse the power and power of attorney. But, as a lawyer, I see cases where they have, so you always have to, whenever you think about doing a power of attorney, you're giving someone else complete access to all your financial accounts and assets and everything.